Hello again, Dan Reel with Fraudclosure 101. I hope you're doing well. I hope you're having an excellent morning like I am. We've started uploading our videos to YouTube and we're doing pretty well. And we have a lot more to go. We have a lot more topics to cover. So this is again Fraudclosure 101. And this is Motion to Open 101. Now there are two types of people who have to file what's called a motion to open. The first type is generally people with no opportunity to bring some sort of meritorious defense, or, something happened along the way where they didn't know there was a foreclosure, they didn't know things were proceeding. Chances are they were talking with a servicer, the servicer was telling them, hey, it's fine, don't worry about it, just submit your modification paperwork or whatever. And the second group of people that usually end up filing a motion to open are people who literally fell asleep at the wheel. So, in brief, what is a motion to open? Why do we file them? We file motions to open judgment when there's something that has to be corrected, something was done wrong, or, first reason, you had a meritorious defense that could not have been asserted. Practical example, let's just say you were in a coma. You got served, the second day after you got served, you, for whatever reason, fell into a coma, you couldn't go, you couldn't attend to it, you had no means to attend to it, you had no practical way. Of course the court would grant it, and as a matter of fact I worked on a case where the guy wasn't quite in a coma, but he was about there, and they did grant it. So generally you get the idea on that. Motions to open have to be filed within 4 months of judgment. So if you run around and you wait until month 4, day 1, you are too late. Absent extenuating circumstances or absent something extraordinary that you have evidence and proof for, you're probably not going to get it granted. Now here's the other thing you have to bear in mind. There's a difference between a motion to open and an appeal. Okay? On appeal, you are looking to correct errors that the court made. A motion to open is not a substitute for an appeal. If you want to file an appeal, and you have to file an appeal because you were there and the court did something wrong, then you have to file an appeal generally within 20 days of final judgment. Now, on appeal, concerning motions to open, this is what makes it extraordinarily dangerous. Motions to open, the standard on appellate review is what's called abuse of discretion. Now, courts have a wide range of discretion on whether to open or modify their judgments, and chances are you better have a good reason. So, bear in mind, again, 1 or 2 reasons you're filing a motion to open is 1, you literally had no chance to bring in, a meritorious defense, or there was information you didn't have access to and you couldn't have possibly gotten it, or 2, you literally fell asleep at the wheel. So again, this is Dan Reel, Fraudclosure 101. This is obviously not legal advice. You should always consult an attorney, but on that note, stay proactive, and you won't have to file a motion to open.